Brendan Miller. You know him. He was a star from the Public Order Emergency Commission show trial, as he called it, before we went on air. Now, Brendan, I'm so glad we have you because, you know, I missed a lot of what was happening yesterday. I tried to follow along with Ezra's tweets. Ezra is, of course, a former lawyer, so he has a unique perspective on it too, and he was in the courtroom. But sorry, my phone keeps resetting itself. Bear with me because I'm in the middle of nowhere. You tweeted out yesterday that the Crown in the right of Ontario prosecuted a mischief trial from the date of arrest, February 17th, 2022, all the way to the date of sentence, October 7th, 2025, for 3 years, 7 months, and 20 days. It likely cost several $1 million to carry out this prosecution paid for by Ontario tax dollars. The Crown sought an insane 7 to 8 years in jail, as I commented elsewhere. That position has no basis in law and defied the rule of law. The available range of sentences was between an absolute discharge and 4 to 6 months in jail. The sentencing judge followed the law with respect to sentencing, whereas the Crown tossed their quasi-judicial role into a fire. I appreciate that, but still, 12 months of house arrest for non-violent mischief still seems insane, given the light sentences we see for recidivists out there who are doing really actually dangerous, harmful things to Canadian society.
Yeah, and I understand your opinion on that, but as somebody who practices criminal law, a CSO, as this is called, which is house arrest, they're considered jail since 1996, real jail, and under the test of set out in Prulix. But the fact is that in this grand scheme of things, you'll see that the case law in this area she specifically followed the decision where I was counsel. I was on for Mr. Van Hugenboyce just for the sentencing. Yes. I wasn't on for trial. His trial counsel took ill, and I took over for him at the sentencing. And in that case, what I did, most of the decision in Van Hugenboyce, the cases referred to are the ones I provided the court. So I did a expose, I guess you could call it, on the history of sentencing for large mischief blockade type protests, beginning with the first one on the books was the ones in response to the Morgentaler decision, which you're probably familiar with, which is goes back to the 80s with respect to the rights of women to have abortions. After that case came out, there was a large blockade and protest of an abortion clinic in Vancouver, and it was blockaded, et cetera. And that's sort of the beginning of the sentencing decisions in that regard. It was dealt with by way of criminal contempt, but that sets the beginning of the area of law in this. And where we're at now is the history of this ends as of yesterday with the decision in sentencing Chris and Tamara. And so there is a long history of sentences passed down for protests that include a form of blockade or mischief. There is probably about 40 decisions in total that I was able to find and provide the court. You'll see that the judge in the Van Hugenboyce case referred to a good chunk of them that I provided him. And basically, what those cases do is they create what's called a range. In sentencing, one of the biggest principles, it's proportionality, but one of the things that the courts do is they look to parity. And parity means that similar offenders should get similar treatment for similar crimes, okay? And so the law then, based on precedent, because we're a common law country, it sets out, based on these cases, it sets a range, right? So depending on what had been done, you could get an absolute discharge, as was sought by the defense in this case. That's within the range that they have been given. There's cases. But the highest sentence ever handed out was 6 months, and it was in the unreported decision, which was for my now client as well, in the Troops blockade situation. Of course, he went down with respect to the firearms offenses, but the court, in a one-page one-off, also sentenced him to 6 months jail
Yeah.
with respect to the mischief. So that establishes the range. So you have, and that's the highest one. Mr. Van Hugenboys ended up with 4 months jail. His situation, the court found more aggravating for a set of reasons, not so much from the time of the offense, but after, is what was the situation there. The other individuals in that case were sentenced to CSOs. So same thing, house arrest, same sentence that Chris and Tamara got. So what the judge here looked at, right, was similar offenses, similar offenders, and you'll see that she turned her mind specifically to those decisions, and she went with those decisions. She found that, yeah, jail would have been appropriate, but it could be served in the community. And that's the basis of her decision, is she followed the law. That's what the law says.
Well, I suppose at the end of the day, I'm glad she did, because we've seen the Crown just really wanting to have people sentenced for the crimes they wish they had charged them for, but could not. And you have to know that the sentence is, as you say, fair and within the guidelines. When somebody like Paul Champ, the lawyer for the Ottawa crybabies, says, he tweeted yesterday, "I know many of the people harmed in Ottawa will be upset, but in my opinion, these are sensible and fair sentences." So that it is reasonable when Paul Champ says it's reasonable. And we also heard from Pierre Poilievre on this. He didn't say a lot about the trial as it was happening. I suppose that's his prerogative, and probably smart, as something is still before the court for the next prime minister of the country, to not delve too deep on it. But I think we can all give credit to Tamara and Chris for unseating the previous Conservative Party leader, Mr. Vegetable Lasagna, Aaron O'Toole. Pierre Poilievre posted, Tamara Lich and Chris Barber peacefully protested the imposition of the emergency measures that the federal court found to be unlawful and unconstitutional. Instead of pursuing rapists, drug dealers, and other monsters, the Crown sought lengthy prison sentences. Justice Perkins McVeigh rightly rejected the Crown's request and sent Tamara and Chris home to their families. We must get to a justice system that ensures the security and freedom of all Canadians. I wish Chris and Tamara a peaceful and happy life. I think that's probably the best thing that he could probably say. I'll throw it to Brendan. What do you think about that statement?
Well, it's at the end of the day, and I don't want to get into political state. I'm a lawyer, and
Right.
though I work for some high profile clients and things like that, and some will, most people don't even know my client list, and they're not entitled to. But
Right.
I can tell you that I work for, I don't take cases on any form of ideological or political leaning. I take cases because people come in and retain me. I believe in the old Barcad rule, which is, if you have an issue that I am learned in, and you come to me and ask to retain me and are able to do that, I take the case. And at the end of the day, what he's talking about is justice reform, essentially, about with respect to dealing with sentencing and bail. I believe that's the big thing right now. There's conflicting evidence on that issue, and it's hard. I get we can trigger a certain awful event happening or any of those sort of things, and blame the justice system for that. But one of the other issues that I saw in this case, and in comparison to now, what we're seeing is these pro-Hamas protests, for example. They're not as long in length or duration, but they are chanting violence at the end of the day. They're calling for the destruction of a people and a nation. And I get you can call that, accuse Israel of genocide is the byline, but I've studied international law, including at The Hague and Leiden, and it doesn't come within that parameter, that sort of a byline. So you're having these things. This is okay, but a bunch of Western Canadians coming to Ottawa and taking issue with the government of the day, basically because it was mismanaged by the police. It was the police who put them where they were. There was no
Right.
intention. There was no intention originally to park where they did. The police put them there. And they were going to do a staging area. And well, I know this inside and out. And the police put them where they were and created the situation. And then they go, well, it's not the situation we wanted. As far as I'm concerned, there had to be some sort of messing around about why that would be allowed. And they probably thought they would only stay for the very short time period of the weekend. And then they would leave because it was cold, but they didn't. So I don't believe for a second that putting all those individuals where they were put with their trucks, that wasn't purposeful on behalf of the police. It makes no sense. It makes no sense. No police force would have ever done that. And for them to say that there was some charter right to drive their trucks to where they were, that's what the police tried to say in defense at the Public Order Emergency Commission. That's a crock of garbage. I have never heard anything like that. And I have a master's degree in constitutional law. So I don't understand, like it's bananas. They created this situation. The government did. They invited them into downtown Ottawa and put them where they were. And then they didn't like the result. And that's what bothers me most about this specific case is that, you invite them and they put you where they are. And then you don't like, at some point, you get to the point where you don't like it anymore. And then you tell them to leave, right? And that then becomes mischief because they told you to leave and that you've upset people around you. I mean, come on, like the people of Ottawa should not be mad at those in the protest. They should be angry at the government that allowed them to set up where they were and put them where they were. And that's my issue.
Oh, I think
I can hear her either.
We don't have Sheila Gunn read audio. Sheila, we can't hear you. We can't hear you. Oh, she's just okay. Sorry, guys. We are painfully live. We like to remind everybody of that as these technical problems happen. But Brendan, where does this leave the Canadian public? Because certainly, I think that there is a prevailing attitude that Canadians have no mechanism to give feedback to the people that they elect, and I think that in the wake of the sentencing yesterday, what people are upset about is that here you have Chris Barber and Tamara Lich being dragged through the longest mischief trial in Canadian history, and yet the people who violated the constitutional rights of Canadians walk away scot-free. How come people in the government aren't being charged? How come bureaucrats haven't been there runs away Sheila Gunn Reid off camera. How come the bureaucrats that were in charge of making those decisions, whether they belong to law enforcement, whether they belong to government or whatever, how come these people haven't been held to the same standard as Tamara Lich and Chris Barber?
Because government agents and crown agents and ministers, etc., have what's referred to as crown immunity. A lot of the time in various different types of immunity. There are certain decisions of government that you cannot sue over. And there is case law plethora to that. There's, of course, the ability outside of all that to sue based on breaches of the charter. That has been done, in particular with respect to the freezing of bank accounts. There has been claims brought. I know, because I was asked to look at it, I know that the individual who was trampled by a horse brought a claim. I know that there are some other civil claims that have been brought, but largely to an extent when the government misbehaves shy of police commissions. And I can tell you, and to be fully fair, and I should only touch on this a little bit because I sit as an adjudicator on the Alberta Law Enforcement Review Board, and I review police discipline. So I won't speak about that very much, but other outside police discipline and outside criminal conduct, there's very little that civil suits can do to change government, for example, to change their actions. There are, in the Indigenous context, there is at times, because the punitive, not punitive, but the compensation and the rewards that tribunals are willing to dole out for when the Crown acts unreasonably is quite large. But when it comes down to charter infringements with respect to damages, the damages to date that have been doled out are not very large, but at the same time, it's only been since 2010 that the Supreme Court of Canada, in a case called Ward v. the City of Vancouver, recognized that clearly that there was the right to bring claims for charter damages. And that's the thing. And you can only bring claims under the charter against government, right? So that's one of the things is that for so long as the damages are minimal and the access to justice and to litigate those issues is minimal, because it's very expensive to litigate disputes. Those are main reasons why there's a lack of government accountability with respect to government conduct generally. So yeah.
Sure. There's no mechanism to hold government accountable for its bad decisions, or it's very, very hard to. Like the bar is very, very high.
Yes, and it's an access to justice issue, right? Like and when it comes to government accountability generally, it's very expensive for an individual, for example, to take on the feds. It's expensive. They litigate. No different than an insurance company would litigate in defense of a claim. It's highly litigious, and I've done it a lot of times. And it costs people a lot of money. It takes a lot of time, and that's where you are supposed to hold the government to account when they won't hold themselves account politically, is you go to the courts, right? And the court system with respect to government and holding government to account, as my mentor, who I have a few, I won't say which one, said to me once. He goes, "Brendan, you always have to remember they have the same stamp on their paycheck as the Crown." So, you always have that in the back of your head, is that, you're in front of a judge who's been appointed by the government that you're typically litigating against. And so there is that. At the end of the day, a lot of judges are trying to make decisions on what I don't think so much is about the law. It's about what they believe to be reasonable. And they fill it in. And I can tell you there's studies from professors about that, like Professor Ian Green, who I had the privilege to study under at Osgoode Hall. He'll tell you that he interviewed all the judges in the Court of King's Bench of Alberta as part of a study. And after interviewing all of them about why they made the decisions they did, do you know how many of those judges, and he interviewed them all, said that it was based on the law?
Tell me.
One.
Oh,
Yeah. So like you have to, and they were all talking about, and so if you look at and this is public, like that book came out in 1996, I think. And the thing is that judges do what they think is practical. And I've even heard judges say, if the law applied to something doesn't seem practical or seems unfair, you can just sort of change the law because we have a common law system, right? Other than legislation. And one of the things, too, the reason for that is in my view, in comparison to England, Australia, and New Zealand, who have similar histories to us with parliamentary systems, Canada post-charter has just kind of left a lot of legislative gaps and left it to the courts so that they don't have to deal with politically hot issues. It is like there's, it's funny.
Abortion is one of them.
Well,
parental rights. Parental rights is another. Yes.
And so they won't go in. They don't want to. And I don't know. I'm not going to get into my stances on any of those.
Sure, you don't have to.
And where the balance is. But here's some easy ones that are not, I think, very
nuclear
hot button issues. So two cases come to mind. There is, well, three really. One on strip searches. Okay, there's a case called Golden, and they the common law set out, how strip searches should be operated in the case called Golden. But it was specifically mentioned in that case, that it was expected that Parliament would look at how this is done. Parliament never revisited it. It's been 24 years. And when a strip search is allowed to be done on an individual by a police officer, it was solely decided by a court as opposed to Parliament. Another one that's, I think, really interesting is, strips with the strip searches, with that one, they also said in Golden that they based the legal test that they made in that case on United Kingdom legislation called PACE. So the court basically adopted UK legislation, all right, on dealing with strip searches, because they're like, well, this seems to be compliant with the charter and it's good. Parliament, go do your thing. This is sort of a ruling that'll be in the interim. Parliament just said, no, not dealing with it, and left it, right? So, and this happens a lot, with decisions of the court. It's seldom that they do second kicks at the can after a Supreme Court of Canada decision, other than in something where they delay the declarations and things like that, like in Bedford with respect to prostitution, or in Carter with respect to assisted dying. Yeah, they revisit the legislation then. And that may be why the Supreme Court started doing these delayed declarations, because the parliament wasn't doing anything. But this happens all the time. The federal parliament and provincial parliaments, to an extent where they're triggered, they leave these issues to the court, and they don't have to. It's crazy to say this, and it's true, but you have more rights at statutes in England than you do in Canada under the charter. It's crazy. So if you're arrested in England, you have a right to have a lawyer present, at your interrogation. In Canada, no, you're not. Though we have, there's no Miranda right, is what it's called. That's been litigated and settled in a case called Sinclair. You wouldn't be allowed in England to do a bunch of things that the police here are allowed to do. It's very interesting what common law countries that don't have a written constitution have created as legislative rights that Canada has not followed suit. And it's debatable whether, despite the fact we have a constitutional charter, that we have as much rights as somebody in the United Kingdom or somebody in Australia or somebody in New Zealand.
That's crazy.
Those are the comparatives. So
it's crazy. I'm so glad you're here to help us navigate this. Now, I saw just some, Twitter lawyers, take that for what you will, saying that Tamara and Chris should have seen jail time because they didn't express any remorse. And Tamara issued a statement. I'll just read it here. She said, Lawrence, that's Greenspan, her lawyer, and I discussed remorse in a meeting at his office prior to our sentencing hearing in July. I told him I would not and could not express remorse, as it would be dishonest and disingenuous. To whom shall I apologize? The thousands of Canadians who stopped planning their own lives to take when the convoy started, to the thousands of Canadians who are able to return to their jobs? Or should I apologize to all the Canadians who can kiss their dying loved ones or have their families over for Thanksgiving? There is no doubt that some citizens of Ottawa felt afraid, threatened, and terrorized. How could they not, when their mayor and politicians were labeling us as an angry mob coming to overthrow the government before we even left Alberta? Do I feel bad for these people? Of course I do. I wish no ill will upon anyone. However, as Brandon pointed out, it was their own leaders who lied to them and misled them. And I suggest also to you, the police that shoehorned the convoy into a place it probably shouldn't have been. There are citizens in Ottawa genuinely afraid of working class Canadians who had never met a trucker or an oil patch worker. I told Lawrence, that day I'll serve 100 years in prison before I will ever apologize. And before my earbuds went wonky there, and then my vehicle picked up the call, it caused a little bit of chaos. I was saying that there's a lot of snobbery through the anti-convoy sentiment. The, you know, how dare these working class blue collar Canadians come to our fancy bureaucratic city? They are supposed to stay in the West and operate as a colony, and they shouldn't get any ideas in their heads about how we should treat them fairly when we get to sit at home on our laptops and complain and then also make our government salary all the time. But that's just my own soliloquy on the topic. What do you think about the subject of remorse? I think they got a fair sentence, but people are saying they should have been in jail simply on the basis of not showing any remorse.
So remorse takes on a different sort of consideration in sentencing when it comes to acts of a political nature. And again, as I told you, I did the whole expose history on sentencing for these types of offenses. And why that is most of the protests, like there's a range of them. I broke them into groups because a lot of them are from, you know, there's a whole bunch of cases on large protests, right? And there'll be one type of protest and a whole bunch of sentencing decisions on that protest. And what has come out in the wash with all those decisions is a lot of times the individual being sentenced is not remorseful, because they're not remorseful because they showed up to protest something, and though they didn't abide by the law by committing mischief or committing the breach of a court order, thereby committing criminal contempt, or committing what's also known as intimidation, which is, it's funny, it's called intimidation. It's just the history of that section, but it's 423 sub 1 or 2G of the criminal code, which is blocking a road, which is a criminal offense. By the way, they could have, like, that is a criminal offense, blocking a highway or road. They were charged with that too in this case, but were acquitted. So there's those cases, and yeah, the individuals a lot of the time don't show remorse because they stick to their guns that they were protesting against what they were protesting. And so the court typically gives minimal consideration in those cases to the fact that the individual wasn't remorseful, because it's the crime. It's hard to divide the crime between the mischief proper versus legitimate political protest. It's a balance always. And that is why the remorse, lack of saying I'm sorry in this case, is only taken to have little weight, as opposed to somebody who commits a violent crime and kills somebody or what have you, and at the end of the day still says they're not sorry. So that's the difference.
You know what? I think we've come to the halfway point of the show. I'm so sorry about the chaos when all of a sudden Bluetooth failed me from the ostrich farm. Lise, thanks for taking control there. I think we're going to say goodbye to Brandon. We promised that we would only keep him for a half an hour, and I learned a lot in the half an hour that you were here. Brandon, do you want to give people a hint at anything that you're working at, or are you keeping a lid on that for now?
I pop up in cases all over the place.
You sure do.
But I try to stay out of the news where I can. But you guys asked me to come on here and have a chat about this, and I didn't mind doing it. So
well, Brendan,
we appreciate you.
Yeah, you are an exceptional guest, and we very much enjoyed having you on. We hope to have you back again, and thanks so much for all you do.
Yeah.
All right.
Appreciate it. Thank you, Brendan.
Cheers.
Let's hit an